number 40, the people of the state of New York versus Richard Gaworecki. Let's take a moment until council has an opportunity to clear out. Okay, good afternoon, council.
Good afternoon. May it please the court, my name is Veronica Gorman. I represent the appellant Richard Gaworecki, and I would like to reserve 2 minutes for rebuttal.
You may.
I'd like to begin by addressing the number of blue bags because I think it's critical to the analysis. Based on the people's proof, there are 5 bags. 1 bag is taken by the decedent on July 20th. The next day he goes to work and he's fine. In fact, there's a corroborating text that he sends to Mr. Gaworecki. Another bag is given to his ex-girlfriend Alicia. She says she takes half a bag and dumps the rest. And then there are 2 bags found by Alicia and the decedent's mom after his death, along with 2/3 of a Xanax pill, which leaves 1 packet possible in the trash can. So I disagree with the people's assertion in their brief that my client used up to 4 bags or 4 blue packets before his death. Also, the blue packet from the trash tests positive for heroin. When they recover the cooler from my client's car, that blue bag tests positive for both fentanyl and heroin. Also, the people have conceded that there was no indication that the decedent had purchased or used blue bags before he bought them on July 2nd or July 20th.
Counsel, I'm sorry to interrupt you.
Go ahead.
What's the standard we're applying here for a grand jury indictment?
Legal sufficiency. Are you?
Yeah, so this argument on causation, and I appreciate the detail, it seems a difficult one to make given that standard.
Well, I would respectfully disagree. I think what has to happen, even though it's not the trial standard, a burden,
Right.
Proof beyond a reasonable doubt, I still think it needs something, and that's what the judge reviewing the grand jury presentation found, which was there has to be something besides just the sale of the drugs alone. And I would say that it's an additional factor. I think that the trial court said aggravating factor. I believe Judge Mulvey said additional factor. Here, there just isn't an additional factor. And I would submit that this case can be decided in line with both Pinckney and the decision in Lee. Because in Lee, the aggravating or additional factor was he's a pain management doctor, and Judge Stein, even in the oral argument portion, asked counsel for Dr. Lee, well, isn't this different? Because he has a higher standard here. He's a doctor based on his training and experience, and I would argue he has a duty to uphold the Hippocratic Oath.
Doesn't that, I'm sorry, over here, doesn't that really go more to mens rea than causation?
Right.
No, I don't think so. I think that it applies to causation just as much, because for the causation argument, he has to have, he has to know what he's doing essentially for causation.
Well, that sounds to me like mens rea, but I'm not a criminal defense lawyer, so
So let me back you up a little bit. So let's assume that for sake of argument, that the victim did die from the heroin that was sold by the defendant to him. Is it your position that the defendant didn't know or could not have known of the substantial risk of death to this individual? Is that what you're arguing to us mainly?
Yes, that is part of the argument, which is, and that's based on the fact that other people were using this heroin, including the defendant himself, and people were not dying. So there's that first indication that the decedent uses it and goes to work the next day and he's fine. We have Mr. Garcia that's using it, and he does have a bad reaction, but he lives. Alicia Reiger, the ex-girlfriend, takes it and lives. So I don't think on its face, he would have known that it was particularly potent.
And what about
Are
his
those all-
admonitions to be careful with this stuff?
Well, so I attribute that be careful text that he sends as more of a friendly reminder in a relationship between addicts. These guys were not only friends, but they were both heroin addicts, and I think that's clear from the proof. And so I would say that...
Why couldn't that be an awareness of the risk under the grand jury standard? Be careful.
Because I don't think it rises to the level that it needs. If you look at the progeny that came after Pickney, that's not enough of an additional factor. You see those cases, we have people that are injecting drugs into the veins of the decedents, and a text that says be careful just isn't enough. Plus,
Can I ask, does a defendant's awareness have to be at the time of the sale, or can it be at any time after the sale?
I think for criminal liability to attach, it would have to be at the time of the sale.
Okay, so when did these events that the prosecutor takes a position made him aware occur? They occur pre the sale or at the moment of the sale?
No, post-sale. So the drug sale is on July 20th, and then the next day, it's purported that Mr. Garcia says to the defendant, hey, I almost died from that stuff, and that there's no indication ever that Alicia Reiger, the ex-girlfriend, ever makes the defendant aware.
Let me give you a hypothetical. Let's say that either these individuals, some other individuals, the girlfriend, it's hard because she gets it from the decedent, but had made those kinds of comments to the defendant. Would that be a different case and then mean he might have been aware and then he fits under the statute?
I still don't think it.
Why not?
I don't think it rises to the threshold that it needs to. And again, how I would compare it is, let's say that the defendant is working on the decedent's car and he puts a V8 Hemi engine in there and he's not an unlicensed mechanic, and he says, hey, dude, be careful with this. It's a lot of horsepower. And then the decedent on his own takes that car and drives 130 because he can and causes an accident and dies. Well, I don't see that how this is any more different than that situation, which is, hey, look, it's powerful. The other thing, too, is that the trial court said that hey, be careful, I hooked you up text also meliates against the recklessness and says that he did, in fact, try to...
Well, isn't it really there is whether strong equals, so this stuff is strong, equals a recognition that there's a substantial risk of death. That's the legal standard that would have to be met, whether that proof establishes prima facie the mens rea, that he's saying, hey, if you take this, you could die. And so that's one question. I want to back you up a second, all right? Let's go back to causation for a second. You opened up by talking a great deal about a number of facts, but really, the defendant here sold heroin with packets that were blue packets, right?
Correct.
Correct. And that when they went through the garbage and when the victim died, there were packets were blue packets and there were green packets, right?
Correct.
There is no proof, forget about weighing the proof, there is no proof that says we can base somehow distinguish in some way for any court between the blue packets and the green packets. And if we can't distinguish, then we don't know if the heroin that the victim or that the defendant sold is the heroin that caused his death. Is that the core of your causation argument?
Absolutely, yes.
All right. So, and I think the grand jury standard here is very deferential. So when we're talking about weighing proof, you're beyond deferential then. And the argument, as I understand it here, is not that you're weighing proof, but there's simply no way to connect what was found with the any logical assumption that either the green or the blue bags caused his death, or if all of them caused it together. And in that being the case, we're once again moving beyond this. So if I got it right, that's the core of your causation argument. On the mens rea argument, I think it's a little more difficult for you because, like I said, you got to distinguish between, hey, this stuff is strong, with the standard, the prima facie standard, where there's a substantial risk of death. But if you're correct on causation, then I'm assuming you're arguing that that's all you need, right?
Correct.
Okay, thank you.
Counsel, why is heroin, with its increased potency over the years, not the equivalent of what we described in Pinckney with respect to wood alcohol, that it's poisonous?
Well, and I'm not really sure what, and perhaps the people could answer that question a little more articulately than I can, but I think it's the introduction of things like fentanyl into the heroin that makes it such a issue, like the mortality becomes so much more significant.
So this would be a different case if there was evidence that the heroin was combined with fentanyl?
Well, no, I think it would be a different case if the people had proof that my client was the one that was distributing it, and by that I mean packaging it for sale, cutting it with fentanyl or anything like that. And there's also the elephant in the room that no one has really addressed, which is this Xanax that is found in the decedent's system. And I believe that Judge Fahey, in your decision in Lee, talked about the depressive effects of both heroin or oxycodone and Xanax. And this has just sort of been sidestepped completely, is that my client has not been accused of selling Xanax to anybody. However, there is a statement in the record from the gentleman who did sell the Xanax to the decedent, and he was never charged. So it's just an interesting issue that kind of stays out that no one's answered.
The Lee case is it may be at the other end of the spectrum of the issues that we're talking about here. Am I correct to say that this is the only prosecution of a street-level drug dealer for this kind of charge in New York State?
That I'm aware of, yes. And I actually went back and I shepherdized Gaworecki to see if any other court had referenced the...
And why would you say that there haven't been these kind of charges brought against street-level drug dealers? I mean, obviously, they get criminal sale and possession and all that, but there's forms of homicide. Why aren't those charges brought?
Because I don't think that there's the requisite level of proof to get over the hurdle of legal sufficiency, even for the grand jury threshold. And I think that that's what happened here. And as I mentioned in my brief, it was the defendant's position that the district attorney who had been elected was taking a strong stance on drug dealers, and drug dealers were going to go to jail. So,
Well, I don't think we're going to hold it against a DA for wanting to put drug dealers in
No,
jail.
I know.
That's not really front page news, but everybody's got to do their jobs. We respect that and understand that. The reason I ask that is because these cases have been difficult to prove, and I just wanted to make sure that I didn't miss any, not so much that they would do it. I wouldn't criticize them for that. Thank you.
Counsel, if we found that the people failed to establish the defendant's knowledge of a substantial risk of death, and there is, the people go back and there is additional evidence developed to demonstrate the potency of the drugs, can they represent to a different grand jury?
I guess they could try. There'd be some complicating factors. The first would be that the grand jury no-billed the criminally negligent homicide, and I attribute that to the confusing instructions that were given regarding the charges. But additionally, some of the people that testified at the grand jury the first time around are dead now, so it would be very difficult. Yep.
Thank you. Counsel?
May it please the court, Rita Basili representing the respondent, the people of the state of New York. With respect to the standard of review for grand jury, we're talking about legal sufficiency. And with respect to whether or not the defendant knew of the risk of potential death.
Counsel,
Yes.
here. So I want to get back to something Judge Fahey was saying about this being a unique case. So you sell heroin, there's a risk of death, right? I mean, it's an inherently dangerous thing. There's a risk of death there, substantial risk of death, I would think. And in all cases, that's there, you get charged with heroin dealing. What do you have in this case that raises to the level of something else, a homicide, right? What do you have in addition to the fact that you're selling a dangerous drug?
Well, I have a reckless manslaughter that there was a justifiable risk that the defendant knew and that he consciously disregarded that risk.
But
And it
what's
caused death.
different about that than I sold heroin? There's always the risk there.
Well, first off, the defendant knew a week before he sold the heroin to the victim, in this case, that the heroin was strong. Because when he sold the blue packets to Mr. Garcia on July 14th, he told him that it was very strong.
Strong.
Very
Okay,
strong.
selling strong, anyone who sells strong heroin could possibly be guilty of reckless manslaughter?
There's the perceived risk that very strong heroin, it doesn't need to be cut with fentanyl to be fatal. And the coroner,
Isn't it really, he's being careful, for a heroin dealer, be careful, it's strong.
well, wouldn't that be the same for Dr. Lee? Hey, be careful when I'm prescribing you these
I think
opiates?
that's a tough analogy, right? So what
As I
else?
recall,
Like,
Dr.
it's-
Lee was warned on occasion that people were at risk of death, and he himself had his own concerns about that. But I do take Judge Garcia's point about strong, how much can one measure that? Isn't that also subjective in the mind of the user when someone says, hey, the stuff was strong for them?
Well, I guess it is subject in the mind of the user, and obviously with addicts, the stronger the better, but also the stronger, the more fatal. And that's what Dr. Prindle testified to at the grand jury with respect to
Well,
the
what
stronger the
do you
heroin.
make of the fact that the decedent said, I already used some, and had survived that?
That was the day that he had sold it to him on July 20th, when he said, hey, just be careful, and the decedent responded,
"Yeah,
yeah, I
you-
already used it.
I used some.
I used some.
So where's that risk?
But
They didn't
but because
survive.
I would submit that there is an inherent risk anytime you're going to sell heroin, and particularly when you know, given all of the literature and
So-
news concerning overdose of heroin, that there's always a risk. There's a risk involved.
Yeah, but where can the people point? What is your contemporaneous evidence that the defendants had an awareness and consciously disregarded it? Outside that statement of be careful, what do you have contemporaneously to show that this defendant actually had an awareness and consciously disregarded it? And at the same time, how do we know it wasn't the green packets that killed the person?
First off, he knew before he sold the drugs to the decedent.
He knew
that
they were
very
strong. There's different variants of drugs on the streets from...
Then, before the decedent died, he knew that Garcia almost died when he injected a portion of the blue packets that he had sold to him the week before. So in between the time he sold the drugs to the decedent and the decedent dying, the defendant knew that this was a potentially fatal pack.
The defendant knew that two
Batch.
people had used it and survived.
Wait, did he not learn that, wasn't it after the sale to Mr. McKernan that the defendant learned that Mr. Garcia said, no, it almost killed me? Wasn't that the day after?
It is the day after,
So
but it's also...
do we measure mens rea at the time of the sale?
I think that it's foreseeable by selling
I have a simpler
strong-
question. What is the point of time where we measure mens rea? When the sale is made? Because I think if it's after that, then what you're doing really is creating a new type of liability for the failure to warn after you learn something.
Well, it would be at the time of the sale, and our position is that he knew it was strong then, because he had warned Garcia a week earlier that this is very strong heroin.
And he did
So-
not, but he did not know at the time of the sale that Mr. Garcia told him, hey, this almost killed me. He didn't know that.
That is true, but he did know that it was very strong. So, and our position is that it would be a strong likelihood that it could cause death. And that's what
And
the
again,
appellant...
Garcia's, this is my problem with this part of your argument anyway. Garcia's statement, of course, is purely subjective. It could be hyperbole. These are drug users, right?
He testified, though, at the grand jury as to what he experienced, the physical reaction that his body had, and that it lasted for 45 minutes, that he had to splash water on himself, and things of that nature.
Yeah,
So
but counselor, the defendant didn't know that.
That is true. The defendant just knew that it almost killed him. But again, our position is that he knew it was strong at the time of the sale to Garcia on July 14th. So fast forward 6 days, he knows that it's a strong heroin because he warned the victim.
Yeah, but that,
In
again,
6
we're back to this other line of questioning, that knowing that something is potent doesn't mean that you fit within the mens rea for purposes of this crime, that it will result in death. Since it hasn't,
Well,
up to then, as far as you know.
That is true. I suppose it,
And of this particular decedent afterwards, for sure.
Right.
Because the decedent said, I used some.
right.
He's
We don't
putting
know
him at
how he
ease.
used it. He may have snorted it, or he may have injected it. We don't know because
Yeah,
it
but
all
it's in,
happens.
it is in response to defendants saying, taking the best view of what you're saying, the defendant's saying, be careful, and he's saying, well, I already used some.
But the same I would submit could be said about the Lee, where there was a number of other patients who were prescribed the same types of opiates and combinations of oxycodone and Xanax that did not die. And also with Lee, it's my the defendant did not know that these people were abusing their prescriptions. Like, the proof wasn't put forth that the people didn't present proof that the defendant knew that these people were abusing their prescriptions. Obviously, I suppose that the jury, as a rational trier of fact, could say, wait a minute, this person a week ago had a prescription filled and then he's back. But what the point being is that opiates, it's a general, oxycodone and Xanax, with Lee, he's prescribing these to many, many other patients that did not die. These people abused the prescription of narcotics that could be potentially fatal if used in excess, which happened to the two individuals in Lee. We submit that the same reasoning could be used here, where the defendant knew he's a drug dealer. He deals in heroin. He knows the heroin. He knows that it's potent. He knows that.
Well, isn't there a difference between potent and deadly, between strong and deadly? I mean, what's the evidence that the defendant knew that what he sold was going to kill him? And are you asking this court, every time a drug dealer deals in strong or potent heroin, that a criminally negligent or manslaughter charge should stand?
No, actually, what we're asking the court to do is to let the jury decide these types of things, because now we're talking about the weight and sufficiency of evidence, which is the purview of the grand jury, not the reviewing court, and that's what the lower court did in this case. Our position is that the lower court usurped the role of the grand jury in determining reasonable cause, instead of just focusing on legal sufficiency, and which is not the standard. And that's our position is that the trial court went too far in its analysis of whether or not the evidence before the grand jury was legally sufficient. And I believe the appellate division below with this case recognized that and said, yes, based on everything that was presented to the grand jury and using the correct standard of review for grand jury review, the people proved a prima facie case. Now let the jury, to allow a jury to decide the ultimate, beyond a reasonable doubt, whether or not the evidence actually would prove the defendant guilty.
Thank you, counsel. Counsel, you have 2 minutes of rebuttal.
Thank you. I'd like to address for a moment the distinction between the strong heroin and deadly heroin. Not only is it subjective, as the court has already pointed out, but it's also a marketing strategy for someone who is selling a product, right? It's strong because a heroin addict is looking for something that's going to be the next level up from where they were. So I can't support the idea or the proof on, or the argument from the people that somehow gave him knowledge that what he had was deadly. And again,
Counsel, I'm sorry to interrupt you, but on this point about the before and after the sale, I share concerns that have been expressed here about the weight of something where you have an addict saying, oh, it nearly killed me. I understand that. But in terms of just a pivot on a bright line, what if I sell someone heroin, that person goes away for a week or so, and in that week, 4 people I sold the heroin to die clearly from the heroin I sold them. That person comes back, come over to my house, and they're like, wow, I haven't used that stuff you gave me yet, and they are about to use it. And I don't say anything. Would you say in that case, because I was warned after I made the initial sale to that victim, it doesn't count?
I think from a public policy point of view, I think that the dealer at that time could say, hey, you might want to...
But forget policy, would you say it doesn't matter what he learned after I sold the heroin?
No, I don't think it does, because I think that it has to be at the time, your mens rea has to be what it is at the time of the sale.
So in my hypothetical, no reckless.
No. No, unless there's some aggravating or additional factor, right, that...
I know 4 people died from the heroin I gave them?
Well, no, I don't think that that's enough even. I think that it would be, if 4 people died from the heroin that he gave him, and then the gentleman that he bought the heroin sits down, injects in front of him, and starts to overdose, and he just walks away and says, or doesn't render aid, or doesn't call for help. I think I think there still has to be some
So you're
other-
saying the additional factor there is not interceding after the person has now ingested in one way or another this, what in Judge Garcia's hypothetical is a drug that at a minimum the seller is now on notice is deadly.
Well, I think that there's an argument that the people could potentially make in that situation. I'm not saying that it would be...
Well, no, I'm just circling back to something you said when you first got up,
Okay.
which was that you need this additional factor.
Yes.
So, right, so I'm just saying, what, in that say, I'm trying to explore what you seem to say the additional factor is if, okay, the guy's ODing in front of me, I don't do anything about it, now perhaps the people can proceed with this, otherwise, no, it doesn't fit under the statute, but if, as Judge Garcia presented his hypothetical, I know right before I see him take out, and you said the needle, they're about to put that needle in him, I don't say anything as the seller.
Yep.
Right? That I don't see why from your view, right, I can't really make my way to your argument here that you have to wait until they actually take it and then try to do something to save them once it looks like they're ODing, as opposed to before, when the quantum of knowledge is the same in both cases. Unless you think actually seeing them ODing is now really the factor that you're talking about.
Well, again, I think that the knowledge that it has, there have been 4 fatal overdoses, I'm going to assume, 4 fatal overdoses, that's knowledge that the dealer has, but I still think that there might need to be something more. And then in all these situations, you also get into this weird issue of the Good Samaritan laws about what happens when people are using drugs in front of you and whether criminal liability can attach when, for your failure to act, and they passed the laws so that people would call in those situations when people were overdosing. But again, in this situation...
But in this hypothetical, the dealer-seller has created the problem, as opposed to someone just walking by and seeing you drowning and doesn't do anything about it.
I mean, if he knows that, the other thing
In this
too...
hypothetical, you push them in,
Yeah, so...
and now you're just standing there.
But there's also a causation argument there too. Like, does the dealer know for a fact that the person in front of him has the exact same heroin out of the exact same bundle that 4 people overdose on? And I think that's a difficult question in and of itself because of how quickly heroin's used and sold.
Thank you, counsel.
Thank you.